few announcements. We do have a new website. Our APASA website is finally up, and we are accepting new memberships. So memberships were paused while we kind of put the finishing touches on the website. But now, if you want to become a member, or if you were a member and would like to renew your membership, you can go to the new website at amishstudies.org and just take it all in. It's pretty fantastic. And then maybe just move your membership to an active status. We would certainly appreciate that. Thank you for joining us today for this roundtable discussion on the 50th anniversary of Wisconsin v. Yoder, where we're joined by an interdisciplinary panel of scholars and service providers and plain folks today to address the complexities of that truly milestone Amish schooling decision. To begin, I'd like to acknowledge Andrea Waxmunsky, who is, as you all know, an integral member of our scholarship committee here and the one who manages the technology to make the event possible. Thank you for all the work that you do. And for those of you joining us for the first time, we just ask that you save your questions for the end of the more formal presentation or discussion. And you can also just put them in the chat if you want to just sort of not lose that thread. And then our panelists can get to them when we begin the more informal discussion afterwards. And today, if you'd like to stick around for about 15 minutes after the session, you're welcome to do so. We're going to try extending the cafe for just a few minutes of informal chat after the hour, and use that as a opportunity to connect with people that you've met through the cafe, and just sort of extend the conversation if you are able. Just a reminder that our next APASA Café will feature Dr. Barrett Janey from the University of Colorado, speaking about early Anabaptism in German historical fiction. And that's going to be a slightly different time. It's going to be on November 4th at 11 a.m. Eastern Standard Time. So just moving that up an hour for you all. And lastly, if you're joining by phone and would like to ask a question, you can just unmute by pushing the star and the number 6, and that should give you access to your voice. It should give you voice access to the conversation. Okay, without further ado, I'd like to introduce you to today's moderator. Truly, I think the man who needs no introduction at all, Dr. Corey Anderson.
Thank you, Natalie. I'm very excited about this APASA Café today, and want to thank the four panelists in advance for joining in on this talk, and all of those who are calling in. I hope it's a very informative conversation across somewhat interdisciplinary lines among our panelists, but then also a conversation here among scholars and plain people and service providers. So the subject of some of the legal foundations of Amish schooling that point back to the Yoder versus Wisconsin versus Yoder decision in '72 is just really fascinating, and there's just a lot of complexities, and I hope that comes out today. And that perhaps there's not always clear answers on maybe the benefit or the drawbacks of this decision, but it really is a complicated conversation. Just to note this decision's relevance a little bit, I saw in the New York Sun, and I'm putting this link in the chat, an article recently on how a precedent one for the Amish, the Yoder decision, could protect the Hasidic Jews. I just found it fascinating that there's that this case that's often just been ascribed to just sort of like an Amish specific decision is in fact still somewhat in conversation when it comes to some other religious groups. At least one of our panelists has spent a lot of time in her own research doing that very comparison. So that comparison of maybe Hasidic or Orthodox Jewish schooling, especially in New York State, and Amish schooling bears a lot of parallels. So without prolonging things much longer, let's get to the panelists. I've got 4 panelists here today that I will allow to introduce themselves. Each of them is going to speak for approximately 7 minutes, and they're going to explain a little bit of the findings from their articles that each of them has published, some of them more recently, others about 10 years ago. And then after that, I have some questions I'm going to pose to each of them. But then I would like to also move into questions that might come up among some of the attendees today. So just a note about this talk, part of this recording will be available publicly, and the publicly available portion will be the panelists discussing their talk and several of my moderated questions. When we get to any audience questions, we're going to make a transition in the recording, and only our APASA members will be able to have access to the remaining part of the recording, which includes any questions audience members might have, or even back to some of my own questions. And then when we get to conversation at the end of the cafe, we will note that it's no longer being recorded. We're just having an in-house conversation. So that'll be the order for today. So I'm going to allow each of the four panelists to introduce him herself, and in turn, we'll start. Let's start with David Cheng, then we will go to Mark Strasser, then Emma Rosenberg, and then Bill Fischel. Just about 30 seconds to introduce yourself, and then we'll come back to each of you to discuss your particular article in that order. So David.
Thank you very much. Good afternoon, everybody. So my name is David Cheng. I am an attorney in Atlanta, Georgia. I am an immigration attorney, and I am very happy to be here today. I went to law school over at Mercer University School of Law, and it was during law school when I first heard about this Yoder decision, and I wrote my article about it about 10 years ago. I'm very happy to discuss it with all the panelists and all the audience members here today.
Thank you. Mark.
Good afternoon. Mark Strasser. I teach at Capital University Law School in Columbus, Ohio. My areas of both teaching and research are in constitutional law and family law. And I have a particular interest these days in the religion clauses. And so this will be, the focus. I'm interested in Yoder in part because of how it's used more generally to sort of bolster religion guarantees.
Thank you, Mark. Emma.
Hi, so I'm actually probably the greatest outlier here. I'm a political scientist and a comparativist, and I focus on the far right in Europe and weaponized religion. So this was a side interest or a passion project of mine. I've always been interested in comparative religious experiences in the United States. So that's where this comes from.
And thank you. And Bill.
Okay, I taught economics at Dartmouth College for a long time. I'm now retired. And I wrote a book several years ago about the development of American schools, school districts in particular. And after I wrote the book, somebody said, a lot of what I wrote about was the transition from one-room schools to multi-grade schools. And somebody pointed out that there are still one-room schools out there done by the Amish. And so, oh, wait a second, I was in my parents' backyard where I grew up in Pennsylvania. So I took an interest in that and wrote a paper about the Yoder decision as a result.
Thank you. I guess we could say for each of you, the Yoder decision isn't a long-going area of analysis, but each of you has spent some time with it and are bringing together some broader expertise that are helping to inform some of your insights on the Yoder decision. I will just take one moment to put that link to the New York Sun in the chat window, in case anyone's interested in seeing that. I mentioned earlier the comparison of the Amish to the Hasidic Jews. And also I'm wondering, Andrea, could you put the links for their 4 articles into the chat window as well from our announcement, just to make sure everyone has easy access to them. Let's go back then and start with David, and I'm going to put a timer on for 6 minutes, and when that passes for each of you, I'll just put a note in the chat window that there's 1 minute left, and then once your time is up, then I will jump in at that point. So, okay, David.
Okay, thank you very much. So, I'm just going to spend a brief moment here talking about the facts of the Yoder decision. I presume many of the audience members have already read the decision, but just in case, I'm going to give a brief overview of what it is. That way we have a baseline to talk about the case. So, Yoder is a 1972 United States Supreme Court case, which, as I stated, piqued my interest when I was a law student back in 2010. So in Yoder, the state of Wisconsin had a compulsory school attendance law. Pretty much all parents in the state of Wisconsin had to send their children to public school, regardless of whether it's public or private, until the age of 16. Now, for the defendant in this case, the petitioner, Jonas Yoder, who was a member of the Old Order Amish, this was a problem. And this was a problem because members of his faith had refused to send their children to public schools beyond the 8th grade. According to the trial testimony, the reason why the Old Order Amish protested sending their children to public schools beyond the 8th grade is because they believe the curriculum provided content which was contrary to their particular faith. And during the trial, there were experts who kind of flushed out what that meant in accordance with the Old Order Amish. They believed in separation from the world according to the religious tenets. They de-emphasized material competition amongst men. And in order to do that, they have to basically separate themselves from secular life. And the Old Order Amish did not believe in sending their children to public schools after the 8th grade because the education curriculum, it provided too much information about intellectual achievement, self-accomplishment, and that is the reason why the Older Amish did not want to send the children to school beyond the 8th grade. Now, it is noteworthy that the Old Order Amish did not object to sending their children to school up until the 8th grade. And the reason for that, according to the expert witnesses, was because up until 8th grade, the Old Order Amish believed that teaching of things like basic arithmetic, reading and writing, it is necessary for basic life, and those foundational principles of education did not really bring forth any type of meaningful competitiveness or worldliness as the Amish sees it. And without going too much about the procedural history, the case eventually reached the United States Supreme Court. And the challenge there was that Mr. Yoder stated that Wisconsin's compulsory education law violated his free exercise rights, his free exercise rights of religion, to not send his child to a public school where the content of the curriculum would violate his Old Order Amish faith. And the United States Supreme Court did indeed sided with Mr. Jonas, finding that Mr. Yoder's free exercise rights were violated because the Wisconsin law basically forced Mr. Yoder to send his children to a public school under criminal contempt or criminal punishment, and the curriculum of the school is in violation of Mr. Yoder's and his family's beliefs. Now, when I first heard about this particular decision in law school, the first thing that popped in my mind was, okay, well, we're talking about, poor Mr. Yoder over here, but what was not discussed in the case at length was the children. So what I wrote about in my article is basically a battle of rights between Mr. Yoder's rights as a parent. He had the right to free exercise of religion as he sees fit. And also, this was not talked about as much, but the Supreme Court also protected Mr. Yoder's constitutional right to direct the upbringing of his children. So there are actually two rights of Mr. Yoder that was being protected by the Supreme Court, although I think the main focus is Mr. Yoder's free religion rights. In my particular article, I talk about how the children's rights were not adequately being considered, because if we think about it, children form their identities and they start forming the choices that they have in life around the adolescent years, and high school around 15 and 16. So essentially, by deferring to the parents' religious rights of not sending an Amish child to a public school at the age of 15 to 16 or beyond the age of 15 or 16, you are essentially foreclosing many opportunities that that Amish child may have as an adult. So one of the explanations I put in my article as to why children's rights may have been discounted back in 1972 when Yoder was decided was because at around that time in the 1970s, this whole concept of children having constitutional rights that are independent of their parents, they were not really fully developed. And around that time, most of the jurisprudence on children's constitutional rights were linked to their parents' rights. However, since then, there have been other constitutional law cases where the courts have held that children have constitutional rights that are distinct from their parents' rights. And these are usually abortion cases where the law requires the children who want, the daughter who wants an abortion to get parental consent first, but the Supreme Court held that this would give the parent arbitrary decision over the child's rights to an abortion. And I know talking about this in a Dobbs world is ironic given the fact that Roe v. Wade has been recently overturned, but I guess that's a discussion for another day. This article was written before the Roe decision was overturned. I also talk a lot about how the Yoder decision from a stare decisis or legal precedent standpoint is particularly peculiar as well. And I see the 1 minute message. How many more seconds do I have?
22.
22. Okay, so I'm sure I'll be able to flesh this out a little bit later. Long story short, historically, the United States free exercise jurisprudence back in the 1800s focused specifically on government persecution of religion. So just imagine a law that says this particular religion is disfavored, but we favor this religion. It's not about a neutral law like what we have in Yoder, where the law simply burdened a particular religion. I'm sure we will circle back around to this later. Thank you.
Thank you, David. The question of children's rights versus parental rights is something that is, I think, going to come up in some other conversations later in this talk. Okay, let's hear next from Mark. And David, thank you for that overview of the Wisconsin versus Yoder decision.
Yeah, and I'm going to sort of start there. So in Yoder, we have these two kinds of interests talked about: parents' rights to educate their kids and free exercise rights. And for what it's worth, the court had already recognized the parents' right to direct the education of their kids. Of course, there was also free exercise, and this was giving some explanation of what that involved. Now, more recently, Yoder and another case, Sherbert versus Werner, have been talked about a lot by the court. The court, I suspect, several, as in a majority on the court, wants to bolster free exercise rights, or at least that's my read. So they're using Yoder as one of the examples of a robust right, a very strong right, and I suspect they're only going to be lending support to that. So that's sort of a little note. Now, one of the things that's interesting about Yoder to me is that it was pretty ambiguous in a bunch of respects. So one, the court noted, or at least implied, the 2 years of extra schooling, which was what was at issue in this case, really wasn't going to help the kids very much. So at least the court implied that the state interest wasn't really very great here in requiring the kids to get the 2 years of high school. Okay, well, why does that matter? Well, that's to suggest that siding with Yoder isn't really hurting state interests so much. So what does that mean? Well, then the question is going to be, suppose there was harm, what do we do? And in various parts of the decision, the court suggested, well, gosh, they believe that this was really harmful. or actually was harmful, then they might have come out otherwise. Why mention that? Well, that actually doesn't make for a very strong right. So that's at least one point to consider, the ambiguity in Yoder. Another thing is the court had already recognized that parents have right to educate their kids, but I sort of posed the hypothetical in the article. Suppose parents, for whatever reason, didn't want their kids to get those extra 2 years, but they couldn't cite religious interests. No free exercise with the division. Well, in that case, it looks like the court would have sided with the state. Now, parents' rights to educate their children, that's thought to be a pretty robust right. Here, we're getting a kind of undermining of that because, but for the free exercise interests, it looks like the parents win. In the article, I also discuss another case, which was a previous case, Prince versus Massachusetts, and that was, about a little under 30 years before. In Prince, what we had was a parent and her child out on the street, and they were testifying. So this is religious, right? And they are giving away religious magazines in exchange for donations. All right, so it's a part of their religion. And the question was whether he or someone, the legal guardian, could allow her, it was her niece, but she's a legal guardian, to do this. And Massachusetts had a child labor law, which had been interpreted by the Massachusetts Supreme Court as applicable. The court held that the state could prevent this child from engaging in this religious activity. One of the things to note about Prince, right? We're getting free exercise as a religious activity. You're also getting parent decision about how in fact, educating the child in religious matters. Court goes the other way. Oh, you might be going, well, that's okay. Yoder is almost 30 years later, different case, but the court is applying Prince, that very case, and just coming out the other way in Yoder. But it apparently believes the two are compatible. So this makes it very confusing as to how to understand Yoder in terms of the strength of the interests. The difference between the two, the court accepted in Prince that there might be harm to the child, and the court really suggested in Yoder no harm. So in that case, it's just very hard to understand quite how to read what's going on. So we get Yoder cited in two ways. One, to talk about the strength of free exercise rights. On the other hand, it's also talked about as representing, well, the state can override both free exercise and can override parental authority in education. So Yoder is pretty ambiguous as to just how to take it. One cautionary, given how the court is going now, and this is where I sort of started, I suspect they're going to make Yoder even more robust, and they're likely to reject a kind of analysis of free exercise that the court had endorsed previously, namely that neutral and generally applicable laws can be passed and enforced even without worrying about free exercise. So instead, I think free exercises get much stronger rather than have Yoder taken back, undermined. Thanks.
Thank you, Mark. One thing that I found really interesting about your article was this emphasis on, even if we don't understand all of some of the contradictions as you've explained them, the the fact is that in the aftermath of Yoder, it had been cited in just contradictory ways. And so Yoder left a confusing message to future courts who seemed to more interpret it along maybe more political ideological lines rather than like actually setting up a like set of tests that can apply no matter what ideological lines you're following. And it's and combined with like the Pierce decision that went earlier, it's sending messages that are confusing the courts. Thank you for explaining some of why it's somewhat of a contradictory, confusing decision, and also your sort of thoughts on where it's going to be going now based on the current Supreme Court. Okay, let's hear from Emma.
Hey, well, first of all, thanks for having me. It's nice being in this environment. So interesting what everyone's doing. Wisconsin v. Yoder, Wisconsin, is one of the cases I examined in my paper. I started off this article being intrigued by the similarities I saw between what I refer to as two strict sects within religions. And sects is not meant to be pejorative in any way. I use that term to refer to literalist religious communities that have deviated from sort of a mainstreamed model in the case of Amish from the original Anabaptist and Lutheran and Protestantism, in the case of the Hasids from mainstream Judaism, Orthodox Judaism, and so on. I initially saw, and start my timer right now so I don't run away with this because I enjoy talking about this. I initially saw parallels between the two groups and how they had adapted to living and surviving in the United States. Both groups had sort of had trial by fire during different centuries. In the Amish, it was during the wars surrounding Anabaptism and the Protestant Reformation, the Peasants' War. In terms of the Hasids, it was continual persecution in Poland, Russia, Eastern Europe, and then, of course, the Holocaust. The United States offered both of these sects an opportunity to survive, thrive, and flourish. But in order to do so, they would have to interact with the American concept of separation of church and state. This affects the Amish and the Hasids in similar ways. Both sects practice a fair amount of distancing from the mainstream in order to survive. The two main threats that these sects face in contemporary life are maintaining internal cohesion and strict practices, and the dangers of external secularism. This manifests itself in terms of keeping a separate language or languages alive in the case of the Hasids, in terms of internal judicial systems, in terms of religious practices out of sync with a secular society, dress, food, you name it. There are many ways to distinguish themselves and keep secularism at bay. At the same time, to exist within the state means to interact with it. This can come in the form of public education, which is the focus of this conference, but also in terms of interacting with sewer lines, tickets on buggies for the Amish, the opportunity to build a religious bath, a mikvah for Hasidic women. And all of these sort of negotiations can chip away at the internal cohesion of the group, as well as the sort of boundary or wall they've erected between outside society and themselves. So for the purpose of my article, I looked at every First Amendment case between the Amish and the Hasids and the United States government at the state level. And I collected dozens of cases. And broadly speaking, what I found was that where the Amish used litigation to further erect a distance between themselves and society, further strengthen their survival outside of society, the Hasids actually used litigation to have societal accommodation. While the Amish fight to keep their children out of public schools, the Hasids fight to have public schools accommodate their very specific needs. And this to me was a fascinating difference. I argue that this comes back to their centuries-old survival strategies. In the Amish case, when they were back being the Swiss Brethren, or in their Anabaptist forms, survival from them was as much geographic, spatial distance from mainstream society they could find. It was about having farms far away. It was about having communities far away. In contrast with Hasidic Jews, largely because Jews were not allowed to own property, there was no way they could have survived in the bucolic wilderness. Rather, their survival strategy was based on finding urban accommodation, finding ways to negotiate and strategize with urban bureaucracies in order to just claw back a little bit of space to survive. So when it comes to their American iterations, we find these historical survival strategies still make sense. The cultures of trauma and survival make sense in contemporary American politics, even though we're hundreds of miles away from and hundreds of years away from their origin stories. So I'm going to stop myself here so that I don't go too deep into Hasidic history. But I hope that what I'm able to do is offer a comparative intra-religious perspective, because very, very often in the study of the political impact of religious groups, we talk about the exceptionalism. And that's important, don't get me wrong. But I actually think that in many ways, Amish and Hasids have more in common with each other than they do with, for instance, Reformed Jews or even Lutherans today. So thank you so much for having me, and I will mute myself.
Thank you, Emma. I really want to encourage these types of comparative perspectives because, just as you said, it helps reduce this view of exceptionalism of each groups and let us know that maybe there's some human tendencies across different cultures and religions that have some things in common, and maybe it can help reveal things about each group you would not really understand just by focusing on that single group. Thank you for your wonderful research and all the work that went into compiling so many legal cases. I mean, it feels like you could have done 5 articles out of that much data collection.
Thank you. I'm not sure my advisor necessarily wanted me to focus on that. He was supportive but surprised.
We appreciate your work. And Bill, I just find Bill's article also fascinating in that so much of what I was reading there was things I was thinking of as well about, I'll let him explain about some of the analysis of how Amish students are scoring and their comparison to non-Amish students, and just some really problematic methodology that was used to support the Yoder decision. So, yeah, Bill, why don't you share a little bit about that?
Okay, I've started my stopwatch, and Lashana Tova. It's New Year's. Emma and perhaps some other people are celebrating New Year's as well. I celebrate New Year's because my wife is Jewish. I am not. I grew up in Pennsylvania. I'm a Pennsylvania German. The Amish were my next door neighbors. Not really. They're in Lancaster County. I was in Northampton County, a couple of counties away, but I've always had some interest in the Amish. That's not why I wrote this paper. I wrote the paper because I had written a book about the transition from one-room schools to regular schools. And my shtick there, my conclusion was contrary to the view that the government made me do this, the state made me do this. I regard it as something the parents wanted to do because back in the early 20th century, they discovered that having a high school education was a great thing for their kids, and they were willing to give up those wonderful one-room schools and herd their kids into the graded schools and the high schools. The Amish did not want to do that. They got off that train, what I call the great national standardization train, sometime in the 1960s, and set out to not recreate, but essentially preserve the one-room school, which was not exactly like the one-room school of the 19th century, but close enough. For the Amish, the virtue was that it was limited. It taught them enough to read the Bible, to learn to read the Bible. Didn't teach them German. Actually, I think they do teach German a little bit because they have to read the German Bible, which is not Pennsylvania German, by the way, not quite the same language. So the Amish wanted a limited education. They wanted some education, but they didn't want it to go too far because they knew if you went to high school, there's the danger you might go to college, there's the danger you'll find a job somewhere else, there's a danger you'll find a spouse somewhere else outside the religion, and you will not be Amish anymore. And they were losing on that account, and so they wanted to withdraw further to the one-room school. The Yoder decision was pushed by different agendas. The attorney for Yoder, William Ball, wanted to eliminate or at least reduce separation of church and state with respect to support for Catholic schools. He didn't get that. What he got was a much more limited, at least as I understood it, Mark has actually done more research on this afterwards, so I'll be eager to hear him on this. They were able to, they're able to send their kids to school, to these one-room schools, and avoid the road to high school that started with the great standardization of education in America. The Yoder case itself was dependent on research by, or lead very heavily on research by John Hostetler, who was the premier interpreter of the Amish for the non-Amish, for the people like that. And he wanted to protect the Amish. He was a great protector of the Amish. And so he undertook a study along with Trudy Huntington. She gets a bit short shrift here. She deserves as much credit, I think. And a graduate student named William Miller, who did a lot of the field work, putting together this study of anonymous one-room schools and graded schools in the Midwest, comparing their accomplishments of the Amish one-room schools to the graded schools, and presented a test, which was a modification of the Iowa test. If you're my generation, the Iowa test was one, again, part of the great standardization of, how much do you know about history? How much do you know about arithmetic and so forth, that was administered across the country. And so he modified this, or they modified this, to test the Amish compared. They did a sort of horse race between them. And it came out to be the Amish were doing okay. What I found from investigating this, mostly from reading Miller's Michigan thesis, got a doctor of education from Michigan, was that they basically cooked the books. They made it very specific to what the Amish could do. And with the Amish were not used to taking tests. They had not taken part of this before. And they sometimes correct the answers or tell the Amish or exclude things. So this is not scientific. There's a number of other reasons why this is wrong. I don't think that this was as crucial as people make it out to be. And that's because I think if you read the opinion, it looks more like a treaty with the Amish than constitutional law. So Chief Justice Berger has this vision of the Amish like they're out of Little House on the Prairie, the yeoman farmers out there, and they're anything but. They are not trying to imitate American life in the 19th century. They have their own agenda, and lack of education is part of it, because if they go to high school, they leave the Amish, so that's the major problem. I think my view of Yoder is, I think the decision is okay. It's the source that's the problem. It shouldn't have been by the US Supreme Court. The state courts were actually doing fine with respect to the Amish. And the state legislatures, I turn around, Wisconsin turned around as soon as the case was appealed and said, oh, we're gonna turn the Amish loose, they can do whatever they want. And Amish now, Wisconsin now has one of the most liberal homeschooling statutes in the country. It's the homeschoolers who have rebelled against the great standardization of American education, and the public is more or less going along with it. So I think the Amish really don't need Yoder. Yoder could be, I don't think it should be reversed, that's a very bad idea, but I think it should be dust pushed to one side. And as I understand from Mark, apparently, or maybe Corey, maybe that's not actually happening, and that's potentially a problem. My 7 minutes are up. Thank you very much.
Thank you, Bill. I just found it so well argued in your article how you showed that there were just multiple methodological problems, and that this was somewhat an example of, I guess, John Hostetler was employing data to kind of back his case without much thought about the methodological rigor or what was actually being compared or what this data was supposed to say. And one of the things that really stuck with me from your article was that he was trying to make this argument that, well, Amish are just as good, if not better, than non-Amish students, but then argued on the other hand that, but in order to protect their unique way of life, they need to be separated from public schools, as if their own schools are trying to achieve the exact same outcomes as the public schools. And so therefore the testing scores are useful to back that up. So it's just sort of like another contradicting message, and sort of, I guess, drives home the fact that, like you said, this decision seemed like in the end somewhat of a treaty specifically with the Amish, and it just made bad constitutional law. And here we are 50 years later, still trying to work through a lot of these kinks, perhaps even wishing that there were things about that decision that could have been different back then, even if it was decided, with a somewhat similar outcome. So I've got some questions, but I'm going to pose maybe 2 or 3 of these, but then I'm going to open it to the floor at that point for people who might have further questions that they would ask from the audience. And if you all prove to be a shy bunch today, I am not short on questions myself. So all of the speakers got these questions a couple days ago. And so I guess one of them, right from the start, is rhetorically the Yoder decision sort of told state governments to just, I guess, back off on Amish parochial schooling. But there was this interesting situation where I think Nebraska several years later said, well, you can have your own private schools, but you have to have certified teachers. And since Amish weren't going on to higher education to get that certification, it effectively did actually bar Amish from settling in the state to have their own parochial schools. So it sort of raises the question, what did Yoder technically decide for Yoder and the others? What technically did they conclude? I mean, reading the decision, it's kind of difficult for me to figure that out. You just like back off of the Amish, but we know that's not really what they said. What did they actually say that the Amish were now allowed to do?
It seems to me it was a negative conclusion of you don't have to go to high school. The states took up some of this and said, well, we've got these homeschooling things you can do and so forth, which were pretty much what the Amish would have done anyway. But I think that the big conclusion of Yoder is a permission not to go to school, not to go to organized schools. That's why it's so popular, I think, with the homeschoolers who were facing, truancy issues too. And they said, no, you don't. The Supreme Court has said we don't have to. We're parents, and we think we can educate our kids better. So you guys back off. So back off is probably the best summary of Yoder, in my opinion.
Mark, you're muted.
Mark?
Yeah, I just undid it and did it twice. So consider, with homeschooling, you're getting some limits, right? You want people to be learning some kinds of things. And a different way to look at Yoder is, gee, we've got sort of the minimum, right? And one of the things emphasized in Yoder is that we have self-sufficiency. Another thing that's sort of interesting is sort of protecting the community. And one of the reasons I'm interested in that is because, at least looking at the Times article on the controversy in New York, you get a kind of distinction between the way the Amish are pictured one of the emphases in the court opinion was they don't need public support, right? Self-sufficient. And one of the things going on, I take it, for the Hasidic community involves difficulty getting jobs because of educate or lack of education, and of course lack of facility in English. So Yoder cuts both ways, the Hasidic community. On the one hand, preservation, that's important. And you can read Yoder to say preservation of the community wins. On the other, how much is the state hurt? The court said in Yoder, not at all. But if they looked at some of the claims about how at least some of the Hasids are doing, they could distinguish. So it makes it confusing all because there's some kinds of standards, even for what's taught, whether at home, in private school, or in public school.
I'd like to build off of that. I think what's so interesting about the decision is it's sort of a retreat from the state in the education of minors in the United States. And while education in religious communities, according to religious mandates, is incredibly important, the one thing that I think Yoder robs children of is opportunity as adults. And that's what I think some of the decisions in the cases involving Hasidic children upstate New York, this is all well and good as long as you want to stay in the community your entire life. But these religious sects, in their purest form, want people staying not through coercion and not through lack of choice. They want strong members who stay because of choice. And I think you're talking the lawsuit where a Hasidic mother sued the state of New York and said, my kids don't have basic skills because there has been no accountability for yeshivas. From my perspective, as I wouldn't call myself a legal scholar, but as someone who studies separation of church and state, which is meant for the betterment of both church and state, I think Yoder does set a dangerous precedent outside of the Amish community. And we're actually seeing these repercussions in, I would say, Christian nationalist groups, in Christian identitarian movements, and in ultra-Orthodox communities as well.
That's a great point that's been discussed, including in some of your articles. Mark, you spoke quite a bit in your article about the potential for harm to children, even if there's not actual harm going on, as a basis in which the court may intervene, as in the case of Pierce, or in the case of Yoder, it said that no one made the argument that there was a potential for harm to the Amish children for not getting higher education. In fact, the Yoder court, Berger, had said that, Supreme Court Justice Berger had said that there is no harm to Amish children for going 9th and 10th grade, because even if they choose to leave, then they've got all these great like work ethic skills, which should help them get along just fine. Maybe all can speak a little bit to what we're talking about now, is that potential for harm to children for not getting a higher education. And then also maybe how do we figure out this question of the rights of the children? It seems like a very difficult matter to like probe an 8th grader Amish boy or girl about whether he or she wishes to go on to high school or not. It'd be difficult to find someone who said, yes, I want to go on to high school. So how is that actually, how's that choice determined? How about if someone would choose to leave later on, are they well equipped in life without that higher education?
So I've talked to one person, one former Amish person, Saloma Furlong, who wrote a book called Why I Left the Amish. And that is very much her point. She wasn't specifically talking about schools, but she thought the Amish had forestalled her opportunity to see the wider world. Now, to some extent, she's an example of, yes, you can escape this, but it took a great deal of fortitude on Saloma's part. And I think it left its mark. So the general feeling about this, I've talked about this to general audiences, mostly academic audiences, but nonetheless, the general feeling about the Amish here is, my feeling is, if you're not of at least two minds about the Amish, you're not using all your bandwidth. That is, of course, there's a strong case for forcing them. The great standardization was, in a sense, a great accomplishment of American education. And it allows us to, both the persons and the society, to gain from being better educated. I'm an educator, how could I disagree with that? On the other hand, as a liberal in the broadest sense, I'm not happy about coercing people to do things they really don't want to do, especially if they have a strong religious belief in that. And so I think that this was like one of those conversations you probably want to avoid rather than head on of should Yoder be reversed or strengthened. I think Yoder should be left the way it is, and people can work around it.
The thing in David's article was, when you're talking about the kids, right, a separate issue is when you're going to be asking kids to make a decision, and there are questions about whether they can be making autonomous decisions at that time. That's only to add a complication, right? Because they're, and one of the things the court pointed to was, unless I misremember, none of the kids had objected. So that made it a more complicated issue. And then there's the further complexity about whether you could really look at the kid as setting his or her own destiny because of their youth. And that was one of the things that I liked in David's article, I'll admit, because that just makes it complicated and even harder.
David, Emma?
I think I'm more familiar, probably because of my background, with the Hasidic dangers. From my perspective, the responsibility of the state is to protect minors and children. That means that no options should be taken off the table until they're 18 and can vote. So children should be able to leave the school system speaking fluent English. They should be able, it should not be impossible for them to catch up academically should they wish to pursue higher education. They absolutely should not be allowed to enter into any marriage before 18, which is a huge issue that's very rarely spoken of among some of the more ultra-traditionalist Christian sects, and absolutely within the Hasidic community. So perhaps because this isn't my academic forte, I feel super comfortable saying that I see this as fairly black and white. We have to protect people's futures and the futures they may not know they want yet.
David?
And I myself, I think at the end of my article, I kind of felt guilty for writing my article, because you read through it, you can see that I'm fairly critical of how the Amish children's rights are being violated. But at the end of the day, I do feel conflicted about the whole Yoder case, because as some of our panelists has pointed to, is that the practical result is that when Amish children, they go to high school, there's a very, very strong chance they're going to leave the Amish community, I guess, just based upon the default that it's a difficult way of life. We live in a generally secular world. When children are being given all these choices, there's just, from a statistical purpose, there's a great chance they're going to choose something else and not just the Amish way of life. So I'm conflicted, because by allowing children to go to school, it really creates a de facto automatic possible destruction of the old order Amish faith as we know it. And if that was the case, this kind of runs against what I talk about in my article. If the end result is a possible destruction of the old Amish faith, an argument can be made that this would be a violation of the free exercise rights in every single sense, because this is almost like the government choosing indirectly to disfavor one religion to extinction. However, on the other hand, children's rights do have to be protected, quote unquote, in a liberal society. You know, we live in a liberal society where we say each and every single citizen should be open to the possibilities of what this world has to offer. And that includes children who are soon going to be adults. As Mark had pointed out, the Yoder court had stated that none of the children had objected to the Amish way of life. Well, how can you? Children do not, in my opinion, and in most people's minds, children do not have the capacity to make that decision. We do not say that young kids have the capacity to consent to sexual relationships. For the similar reasons, children would not really have the capacity to make that kind of decision until not only they develop the mental capacity to make those decisions, but also they cannot make that decision unless they're given meaningful choice or given different alternatives, having exposure to different things. So that's why in my article I talk about how the children's right to an open future is violated by deferring to the Amish parents' rights. But it's a big conflict there, because if you go the other way, like I said earlier, it can very likely lead to de facto destruction of the Amish faith. So it's a no-win situation.
It's a very hard point. Wanting to make sure that children at least have access to other types of life, and at the same time not so imposing it on them that they end up taking, I guess, whatever is the laissez-faire, fashionable style of the life of the day that just seems to have the most clout and pull to our entire globe. Do we necessarily need to just herd everyone into that kind of lifestyle? So it's a difficult question that I don't think is just going to go away very easily. And perhaps we can have a little bit more sympathy on the justices who decided Yoder, because this was really at the crux of their decision. Piggybacking off that point, I've got one more question before I'm going to open it up to audience members here to share their questions. But I've got one more question that kind of follows this. So there's two things that I've noticed going on among Amish in the large settlements that could have some ramifications about this question of children's decision, and also perhaps the Yoder decision. One is that the Yoder decision very much praised this agrarian lifestyle where children who leave 8th grade are working at home with their parents, developing like manual skills and a diversity of manual skills to help them someday become farmers themselves. And the vast majority of Amish are no longer full-time farmers. In particular, in the big settlements, there has been an industrial revolution where now most Amish are not agrarian, but are working class and are working either in construction, or they're working in factories. After 8th grade, especially with the recent demand for new employees that happened in the COVID, the shortage of employees that happened during the COVID period, I just saw this increased demand in these large settlements for workers, and saw specific advertisements going out saying what like ages they'll accept for minors into factory settings where there are workplace hazards. So knowing that they're leaving 8th grade and likely being channeled into industrial settings where there's workplace hazards, it seems like there's now questions of, is Yoder actually enabling like a 100 years ago, like child workforce supporting an industrial complex where people at the top seem to be getting rich off of the exploited labor of minors. The second thing, as we heard from last month in our talk from Stephen Thalheimer, that there are still public schools that have Amish in them. Here we are 50 years later, and it doesn't seem like there's a mass withdrawal 100% into parochial schools, even though most Amish have withdrawn. In Holmes County, Ohio, there's both mixed Amish, non-Amish schools, and there's several public buildings where it's entirely Amish population. Northern Indiana, there's no entirely Amish populations, but they have mixed schools with majority Amish. In the Buchanan County, Hazleton, Iowa area, there are still one-room schools in the countryside that are entirely Amish that are public schools. And I think in Arthur, Illinois, there's mixed school as well. Are there ramifications there for the Yoder decision or Amish free choice, in as much as that says Yoder was not necessarily representative of every last Amish person, even today, in their schooling decisions? So two things I'm putting before you, the sort of the industrial complex that's grown that negates this agrarian narrative, and also the persistence of Amish participating in public schools.
You know, one thing to consider, as a general matter, we have to consider that individuals, even within communities, may have different takes on what they want and what they want for their kids. So the fact that some want to place their kids in the sort of the mixed schools or in public versus not, likely not imply or entail that others who don't want to go that route should be forced to do it. Now, I don't read Yoder as saying there's a unified view, but rather that those who didn't want their kids to go to 9th and 10th grade, but who were below 16, wouldn't have to. So I don't think you're going to be getting that. And as a general matter, we have laws that are supposed to be protecting individuals who are working. So I understood your point, and that's sort of interesting to see the change in what people are doing. But also Yoder said, hey, productive, let's let people continue as long as they're productive. And if you're getting a shift from agrarian to manufacturing, I assume the Yoder court anyway would still say we made the right decision.
Can I shift this over to the skill set? And I'm going to tell an anecdote which I think illustrates the part of the problem. I was talking with a young woman. Actually, I'm not sure of her pronoun. I think she's transitioning to a man. But at any rate, they are now trying to get a job or getting in a training program for a machine tool company, working in a manufacturing firm, not as a manager at all, but a line worker. And she said, or he said, or they said that a number of people were the co-workers, weren't able to do it because they didn't know enough algebra. You need algebra to be a machine, to work in a manufacturing plant on the line. You need to be able to understand concepts that to manage what's going on. This is not Lucille Ball picking stuff off the candies off. It's actually doing something, but it's an entry-level job in manufacturing. I think the Amish education would be insufficient for that. And so I think we need to understand that just because they're going into the entry level doesn't mean that their education is going to be enough.
And of course, go ahead, Emma.
Then Emma. David and then Emma.
Oh, sorry. Yeah, I was gonna say that I think, and this is me speculating a little bit, but I think it is going to be increasingly difficult for the old order Amish. I know there's many different sects, but for the most, it's going to be very difficult for the most conservative sects of Amish society to maintain their strict separation from the world attitude. This was not in my article, but based upon my research and writing the article, you know, I don't know too much about the entire history of the Amish and their different sects. I think Emma is probably much more knowledgeable than me. From my understanding, the religious tenets of the older Amish has actually changed a little bit over time. Some sects have started to use telephones, some have started to use motor vehicles. As these inventions first came about, the initial reaction is we're going to definitely stay away from this because this is, the material world. This is very worldly. But, we live in the real world. There's real economic needs amongst all societies, including Amish societies. Over time, there has been a certain molding of the religious tenets to allow exceptions to certain members to use telephones in limited capacities, cars in certain capacities. And I think as these particular tenets change, there may be a risk, I'm not sure how great that risk is, that the justification for the Yoder decision, which is that the separation from the world is necessary under the most material, important tenets of the Amish religion, that particular reason may start to break down and be undermined.
The diversity among Amish and plain people more broadly is vastly greater than probably even when you wrote the article. Emma, go ahead.
So I want to speak to two things. First, I think one of the things that's important to remember is there's been a flux in state capacity. When the Amish and the Hasids formed, state capacity was low. They couldn't oversee things. They couldn't oversee taxes. They couldn't oversee sewer permits. They certainly weren't overseeing public school systems. But at the same time, there was no real separation of church and state. So while it's harder to escape the government these days, there's less coercion from the government to push forward a certain type of religion. So while I think that matters in terms of course, there are new temptations with secularism, but there were always temptations with secularism. This time, the government's not trying to force them to be a certain kind of Christian. But I want to get back to what you said earlier about farming life and agrarianism. I think one thing that we don't talk about with Yoder is kind of the normative side of it. I cannot imagine Yoder, that case going the way it did for a Jewish community, a Muslim community, certainly not a Black Christian community, where they said that an education which selectively reimagined American history was detrimental to their students as well. I think that Yoder was possible because Amish values were seen as inherently good. Hardworking, working the land, it very much fits into an understanding of the best part of America, but I don't think it could have happened in very many other contexts.
Thank you, David, Mark, Emma, Bill, for taking this time out of your day to join us in this conversation and all that you've added and enriched here. So thank you all. We hope you can join us in the November Cafe as well, when we'll switch directions totally and look at some perceptions of fiction writers of the Anabaptists in Europe. So, all right, feel free to stick around or sign off. Thank you, everyone.